Welcome back to This Explainer, everyone. Today, we're literally cracking open the foundational rulebook of criminal law. We're going to go through a comprehensive list of the key cases that define the exact boundaries between guilt and innocence.
Here's our roadmap. We've got 6 parts to cover today: intent and the mind, assault, battery, and harm, causation and the link, the duty to act safely, consent and self-defense, and finally, strict liability rules. Let's dive right in.
Section 1, Intent and the Mind. We're kicking things off by defining the criminal thought process.
So the courts actually draw a really hard line between 2 very different mental states. Look at the Mohan case. That establishes that direct intention means you purposely made a decision to bring about a prohibited consequence. But then you have the Cunningham case, which shows us that recklessness is entirely subjective. It means the defendant actually foresaw the risk of harm, but, well, went ahead and took the risk anyway.
Now, historically, the law used an objective test for this. What would a reasonable person foresee? That standard was clearly established in DPP versus Smith. But that test evolved. By the time we get to the Woolen case, the bar for indirect intention shifted to a highly subjective standard. The harm basically has to be a virtual certainty as a result of the actions, and, crucially, the defendant must actually appreciate that fact.
But wait, you might be wondering, what if you miss your target entirely? Well, the case of Latimer establishes the rule of transferred malice. This kicks in where a defendant intends harm to one person but accidentally causes harm to someone else. The liability simply transfers to the actual victim. So, bad aim absolutely does not get you off the hook.
All right, moving on to Section 2, Assault, Battery, and Harm. Let's look at the physical and psychological impact.
You see, assault isn't just throwing a physical punch. This literal list of case law proves it takes so many different forms. In Logden, we see that a conditional threat counts if the victim fears immediate violence. Constanza shows us that words in repeated communications causing psychiatric illness count. In the Ireland case, even silent phone calls were enough because they caused fear of immediate violence. Then you've got Collins versus Wilcock, where the intentional or reckless application of even slight unlawful force is considered a battery. And DPP versus K proves that even indirectly applying force, like setting a trap via a chain of events, totally qualifies.
To understand the really severe stuff, we have to define grievous bodily harm, or GBH. This is perfectly shaped by 2 foundational cases. First, Eisenhower dictates that GBH means really serious harm, though interestingly, it doesn't have to be life-threatening. And then Burstow expands this significantly, establishing that serious psychiatric injury can constitute GBH even without any physical violence whatsoever.
Notice how the intent requirement scales right along with the severity of the charge. At the lower end, for actual bodily harm, cases like Savage and Chan-Fook show that just being reckless or having intent for a basic assault is enough. And yes, that includes recognized psychiatric illness, not just mere distress. Stepping up to Section 20 GBH, the Mowat case says the defendant must foresee at least some harm. But when we move to the absolute most severe charge, Section 18 GBH, cases like Belfon, Morrison, and Taylor set a remarkably high bar. They demand a strictly interpreted, specific intent to cause really serious harm or to resist arrest.
And in a fascinating modern application of these ancient rules, the Dicka case confirmed that recklessly transmitting a sexually transmitted infection actually amounts to grievous bodily harm.
Section 3, Causation and the Link. Connecting the action to the consequence.
So we have the intent and the harm, but the foundational rules for causation require a clear operating link between the two. The Thomas case establishes that a clear causal link absolutely must exist between the conduct and the harm. The 1959 Smith case tells us the defendant's act must be an operating and substantial cause, and that bad medical treatment rarely breaks that chain. And incredibly, their Hicks and Mason cases prove that death from fear caused by an unlawful act still establishes causation, meaning yes, you can literally scare someone to death.
Once that chain of causation starts, it is incredibly hard to break. Look at this timeline. A victim's expected reaction, the Roberts case says that doesn't break the chain. A foreseeable police response, Paget says that doesn't break it either. Even doctors switching off life support in Malcherek and Steele keeps the chain intact. According to Williams and Pembleton, the only thing that truly severs this link is a completely free, voluntary, and unforeseeable act by a third party.
Section 4, Duty to act safely. This is all about when doing absolutely nothing is actually a crime.
You aren't always legally obligated to intervene, but specific situations create a binding legal duty.
If you create a dangerous situation, like a fire, the Miller case says you must act. Santana-Bermudez establishes a duty if you fail to warn a victim of a danger you created. Stone and Dobinson shows that voluntarily assuming care for a vulnerable person creates a duty. In Gibbons and Proctor, we see that a parent-child relationship means failing to act can quite literally equal murder. And the Ditham case proves that if you hold a public office, you cannot breach your duty by just standing by.
Section 5. Consent and Self-Defense. Let's explore the legal justifications for harm.
The boundaries of personal autonomy here are fascinating and strictly guarded. Look at this contrast. In the Brown case, the court ruled that consent is totally invalid for actual bodily harm in the context of sadomasochistic activities. Yet, in the Wilson case, they ruled that consent is valid for conduct comparable to tattooing or extreme body modification. It's a really interesting line the courts have drawn.
When it comes to self-defense, two major cases set the rules. First, Gladstein-Williams. This case states that a defendant can rely on self-defense based on an honest belief that force is necessary, even if they are completely mistaken. Then, the Martin case adds the crucial modifier. The force used must be reasonable based on the circumstances as the defendant genuinely believed them to be. So ultimately, you are judged on your honest belief of the situation.
Finally, Section 6, Strict Liability Rules. Guilt without fault. Which brings up a really critical question for this explainer. Can you be criminally liable even if you acted completely reasonably and meant absolutely no harm?
Generally speaking, the answer is no. Cases like Sweet v. Parsley establish a strong presumption that criminal offenses require mens rea, a guilty mind. And B v. DPP reinforces that courts heavily favor this presumption of mens rea unless Parliament clearly states otherwise.
But here is the ultimate exception to our rulebook: strict liability. For certain specific offenses, your intentions and the precautions you took simply do not matter. In Callow v. Tilstone, liability arises even if the defendant acted reasonably and without fault. And Cundy v. Lecoq proves that guilt is based on the act alone, regardless of your knowledge or intent. You can do everything right and still be found guilty. To wrap up, the rules of criminal liability are not merely a list of prohibitions, but a complex map defining the exact boundaries of human intent, bodily autonomy, and social duty. As we look back at this literal list of foundational cases, we really have to ask, does this intricate web of strict rules and subjective tests actually capture the messy reality of human behavior? Or are we just constantly finding new ways to test the very boundaries of justice? Thanks for joining me on this one. See you next time.